Hello and welcome. I am Chakshu Roy and you're watching Laws in the Making on Rajya Sabha TV. Today on the show, we are discussing the Insolvency and Bankruptcy Code Amendment Ordinance 2019. To discuss the ordinance, I have on the show with me Mr. Subhamay Bhattacharjee, Consulting Editor of the Business Standard, and Mr. Sangram Patnaik, Corporate Lawyer. Insolvency is a situation where individuals or companies are unable to repay their outstanding debt. The code enacted in 2016 provides a time-bound process for resolving insolvency. The ordinance sets a minimum threshold to apply for insolvency proceedings and provides immunity to the corporate debtor from prior offences. The ordinance came into force on December 28, 2019, and a bill to replace the ordinance has been introduced in the budget session of Parliament.
The code allows the debtor and its creditors to initiate insolvency resolution process if the amount of default by the debtor is at least 1 lakh rupees. However, it sets no minimum limit on the number of creditors. Under the code, a financial creditor, either by itself or jointly with other financial creditors, could file an application before the National Company Law Tribunal or the NCLT for initiating the insolvency resolution process. The ordinance introduces an additional requirement for certain classes of creditors, requiring them to apply jointly only.
No, basically insolvency proceedings are against those individuals or companies where they are unable to pay their debts. And now there is a time-bound resolution process. Now by this ordinance, efforts are being made so that some practical difficulties are removed so that they can be revived in real manner and they can come out from the insolvency proceedings.
In cases of real estate projects, the application should be filed jointly by at least 100 allottees of the same real estate project or 10% of the total allottees, whichever is less. For other financial creditors, where the debt owed is either in the form of securities or deposits or to a class of creditors, the application should be filed jointly by at least 100 creditors in the same class or 10% of the total number of such creditors in the same class, whichever is less. Creditors unable to meet the threshold of their respective class will not be eligible to initiate insolvency resolution process, irrespective of the defaulted amount.
The entire corporate insolvency resolution process, I think there is a misnomer or there is a misconception amongst the public at large that whenever some company is sent for resolution process or a proceeding under IBC is initiated, that essentially means that it will actually lead to winding up of that company or that the company will be declared insolvent straight away. So that's not what really happens. Corporate insolvency resolution process, even after IBC or even before this, so all those proceedings which used to happen for winding up or under SICA, that is the previous act, so the objective is to actually revive the company.
The code restricts certain corporate debtors from making an application to initiate the insolvency resolution process in 4 cases. These are the corporate debtors undergoing an insolvency resolution process, corporate debtors who have completed the resolution process 12 months before making the application, corporate debtors or financial creditors who have violated terms of the resolution plan, or corporate debtors in respect of whom a liquidation order has been passed.
Mr. Patnaik, the corporate insolvency law was passed in 2016. It was the first, comprehensive insolvency legislation of the country. But over the years, between 2016 till now, there have been multiple amendments. Can you, walk us through as to what has been the history of the law itself and what the amendments have been so far?
See, the reason behind the statute, particularly the IBC code, which came into picture in 2016, after much more deliberation that has taken place, particularly the BLRC report and all, for which there are a number of statutes earlier. Number one, the SICA Act used to be there, where there is a resolution process or revival process or rehabilitation process of a company under liquidation, or which is about to be liquidated. So we used to refer to, in practice, in normal practice, in the court of law, we used to refer to several statutes. For example, SICA Act, Companies Act, you go for that, and then the RDDB Act, and then the SURFACI Act. So there are so many statutory provisions which you have to go through. at times what used to happen is that there is overlapping. For example, there is a much debate which used to happen that yes, the Indian litigation system takes much more time in comparison to other litigating countries. For example, in UK, a resolution process takes 1 year, in US 1.5. So why in India we take so much of time? That is, the people in general also thinking about, no, if you go to the court of law to adjudicate in dispute, it takes a lot of time. So to end all those things, the lacunas and the overlapping part, and suppose, for example, I'll give you one example. There is a revival process under the SICA Act. So after the recommendation of the SICA that yes, this company cannot be revived. So you refer that opinion to the concerned High Court where the jurisdiction lies, and then you go for the winding up. So the basic fundamental issues that this company cannot be revived. So therefore, you go to the concerned High Court to close that company or to liquidate that company. Now, in one forum, you will get everything. Suppose it is let me put it in this way, that is one window solution for a rehabilitation process and then the liquidation. Suppose it is not happening. You cannot wait for, or you cannot go to another forum to liquidate that company. So I would definitely, whatever the experience I had in the bar, this is a process where it is a step in the right direction. It may take little bit of time to come out of its own embryo. For example, there are a lot many amendments which is coming up. I would not say the people who have settled this law or brought about this statute are myopic, but it's a requirement of time and the need of hour. For example, now this recent amendment which has taken place, I would refer to, of course, the earlier amendments where the 330 days period is the maximum period. Earlier it used to be 6 months. Now 330 days period, you have to go for the resolution or go for the liquidation. There is no other period which would be given as a leverage. So let us come to the next amendment which has taken place. Now for that also, the people are so vigilant, they go before the Supreme Court to challenge the wires of the statute or the amendments. Now for the simple reason why it should not be, like for example, this amendment which has taken place, 10% of the total home buyer or 100. Suppose for example, you are only having 99 people together. Can you go for the NCLT? Answer is no. Whether it is injustice to me as individual or 99% people. So all those things would come into picture. Of course, with the passage of time, the law will settle, the dust will settle, so that we will not refer for the amendment after amendment.
And Mr. Patnaik, we'll discuss, that 100 limit and the 10% limit. But Shubhamoy, if you can, give us a little bit of a context as to, this is the second attempt at which, home buyers, there's an amendment that has come into IBC. The first one was obviously, to recognize them as creditors. What has been the need for this amendment to put these limits of 100 or 10%, especially when it comes to home buyers?
Yeah, interesting. In fact, that is one of the principal reasons why this amendment came along. And the reason for that is that there have been several cases, and Delhi is a great fertile place, the Delhi NCR region, where lots of these cases have come up. And one of the reasons why that came up was that precisely the chance of there could be a frivolous one, or there could be chances where that the project might simply be stalled because of almost like a related party transactions without getting into names. Now this is where the problem is sought to be sorted out by saying that you got to have adequate skin in the game for the home buyers to be able to take a promoter to the court. And this is the fundamental reason why this ordinance, as we see now, has come into place, and which is where, interestingly, if you look at, in fact, the other amendments which have come, most of the other amendments, they were to do with the financial creditors for the other sectors, larger sectors. But the home buyers by itself, since RERA has really not come into place as such as a vigorous organization, as a vigorous tribunal, it is here that is the home buyers disputes and others are being played out. And I suspect there will be a couple more before we get this thing actually settled out. It's in fact, there's a possibility that sometime later this could be carved out, but that we can talk about later. But it's essentially, yes, the fact that to avoid too many chances of going the other way. The first part was that in the first line, the point was home buyers could be protected on the insolvency, which was the nub of a earlier ordinance. This time the point is that you can be protected, but don't sort of use it as a forum to settle your personal scores.
Okay, so don't use it as a forum to sell the parents' cause. Mr. Patnaik, one of the things that the original code decided to do was to put a financial threshold at which, a creditor could kick off, insolvency proceedings. And that threshold is a financial threshold of 1 lakh rupees. So if you're a creditor and you're owed, more than 1 lakh of rupees, by a corporate, then you can initiate proceedings. Now, there's a parallel threshold that's coming up, which is the number of, creditors that are in place. And in case of home buyers, it is 100 people or 10% of the total cost. What do you think, leads to this 100 or 10%? Is it to ensure, frivolous petitions are prevented?
See, now I would definitely submit that this matter has taken up to the court to test the wires of this amendment. But, that is pending. 13 January notice was issued. Now it is stayed, or status quo is to be maintained with regard to this notification. That is fine. But I would certainly, it comes to my mind, frivolous litigation must be thrown in the dustbin. Absolutely no difficulty. Can there be a genuine person, 99 or 50% or even 10%, who, despite that there is a default on the part of the promoters or the builder, can I be allowed to approach the NCLT? If not, why not? Now, suppose, for example, it may so happen I couldn't able to gather 100 persons together to challenge, or 10% even. 10% of the total or 100% together. Suppose I could not able to do it. Therefore, I could not able to agitate this issue, which is a substantial issue, whether there is a default on the part of the promoter or the builder or not. Now, those things should be gone into. For example, see, it's not that 10%. 10% is always, there is a provision. For example, there is Operation Mismanagement in the Companies Act. So, 10% of the shareholders can approach to the NCLT. That's the provision. No difficulty. Here, it's a, I would not say the poor, but innocent home buyers who doesn't know the nuances or the basic parameters of the law on the basis of which they would challenge. But whether I have a genuine grievance to go before the court to say, here is a case, I have invested this much of money is not returned, nor the flat is given. So whether I have a remedy under the bankruptcy code or not, that issue need to be decided. Of course, I agree with this contention. There are a number of frivolous home buyers, maybe no difficulty. But you cannot certainly throw the baby in the bathwater for the simple reason, because there are a certain chunk of the people who are actually the frivolous home buyers or claiming to the home buyer. That should not be a personal settlement of the score with the builder. Absolutely no, big no. But if there is a genuine home buyer who could not be repaid in time, or the flat is not given, I would simply submit that yes, it should be, this home buyer should be given a chance. Of course, since the matter is pending by the Supreme Court, it would be heard in length, both that whether this 10%, which is the cap which has been given or been put in the amendment clause, whether that is valid or not valid, that time only will speak for itself.
Okay, and while that's an interesting point, but it's time for us to head into a break. When we come back, we will discuss amendments that the ordinance provides for the moratorium period and immunity for certain offences. Welcome back. On the program today, we're discussing the Insolvency and Bankruptcy Code Amendment Ordinance 2019. The ordinance amends the 2016 code to provide additions including immunity from prior offences.
The code allows for a moratorium period. The moratorium is the period during which the National Company Law Tribunal may prohibit people from taking certain actions against the corporate debtors, such as filing of recovery suits. The code allows the adjudicating authority, that is the NCLT, to allow supply of essential goods and services to the corporate debtor. The ordinance introduces a new category of critical goods and services to be decided by the resolution professionals. This provision will not apply if current dues are not paid to the suppliers.
I mean, in case there is a debtor who actually is accused of doing something wrong, in the sense, in the eyes of law, related to the company, then and a new entity or a new buyer steps into his shoes, then what these amendments seek to do is that the liability won't be fastened upon the new person. Person is the juristic person or the new individuals. So that is also a good step.
The ordinance adds the provision that any existing license, permit, registration, quota, concession or clearance given by the central or state government or local authority will not be suspended or terminated on the grounds of insolvency. However, there should be no default in payment of current dues for the use of continuation of such grants during the moratorium period.
Purpose of this bill and original code is to revive the industry or the person or the company which are going through the insolvency proceedings. Now, if the critical services or the goods which are required for revival of the company are discontinued, then that purpose is defeated. So, by this amendment, provisions are made so that essential goods or services cannot be discontinued during the moratorium period.
The ordinance adds a new section providing immunity from prior offences. In cases where the insolvency resolution results in the change of promoters or management of the corporate debtor, it will cease to be liable for offences committed before initiation of the insolvency process. The liability will cease from the date the plan is approved by the NCLT. The immunity will not apply if the person was a promoter or in the management or control of the corporate debtor, or is a person who the investigation authorities have reason to believe to be a conspirator.
So, Momo, I wanted to begin the second part of the program with you and asking you about this moratorium period, especially in case of essential goods and services. What is that about?
Well, it's essentially saying that guys who have got a case already against them can jolly well say that there's a fresh case in which I'm interested in. Essentially, and it looks quite a bit of funny. I mean, like, status in one case should not be the reason why the status in another case should be jeopardized. But it's the funny world of Indian business, where companies which often are not very keen to look after themselves are quite keen to look after other interests. If one looks at what's happened through the newspaper pages, you would find that there have been cases where the companies have bid for a project under the insolvency under the NCLT through the IBC, and then bids have not gone through, or they have not been able to pay up, or whatever. But then a new property comes along, and these suitors are there again with their new with a new project saying, no, we are interested in this. I can understand. It's like saying that when I'm shopping, I mean, if I drop a particular project, I can shop something for something else. But frankly speaking, it's not as simple as that. I mean, if you have been not interested in one particular project, then what's happened is that the resolution professionals and others have spent time weeding out others in favor of these guys. Now, these guys then say that, no, hang on, I have, interest in, not treaty shopping. It's almost like treaty shopping. Like, I have a shopping interest in some other project which has come up. I didn't know this one was going to come up. So, therefore, I make my bid for this. Frankly speaking, it's something on which there can be lots of cases, but for anybody with a good sense would say, no, this is frankly not done.
Okay. Mr. Patnaik, I saw you smiling on that particular point. Clearly, you want to add something about that.
I'll tell you, moratorium period is essential. I mean, whether we accept it or you don't accept it. Somebody is in oxygen, this company. You need to provide the entire support to get this company thrived, survive, and at some point of time flourish as well. The purpose is not to liquidate. The basic intention, the basic fundamental intention of this legislature, the IBC, is for the revival. If not, then liquidate. So you cannot say that this company need to be liquidated. So therefore, this moratorium period, the basic intention of moratorium period is what? That you cannot initiate, proceed any distress proceedings against the company where the resolution plan or the IRP is already appointed. That's it. Now, for example, you would not say, I'll take away your hand, I'll clip your leg so that you cannot run. You need to provide the basic amenities. For example, why the other amendments are there also. Moratorium period, according to me, is a must. Secondly, suppose, for example, you would say that why that kind of leverage is given. I would say that suppose there are essential goods. I'm a manufacturer of cotton, right? You would say that, no, this company has gone for the IRP process. or the resolution process, I would not provide the goods. Naturally, you would be scared as a supplier. It goes without saying. But can you stop it? Answer is no. But I'll tell you the process. Suppose you provide the goods during the resolution process. You have the priority of getting the cost of those goods as a priority in terms of the financial creditor or the operational creditor, because that would be covered under the cost of the resolution process. The moment you stop it, that yes, you are not going to provide the services, we are not going to provide the essential goods, then the company is, gone. That's the intention of this amendment. You cannot stop it. Moratorium period, mandatory. I would, that's my take. Of course, I may be wrong or right, but moratorium period is essential. Then the third aspect, which is the most important thing, the people think that the promoters who are actually is responsible or the villain of everything. According to me, probably it is on one of those bad days or not the good weather where this company could survive or thrive. But you cannot certainly liquidate at the first instance. That is the intention of this legislation. Go for a revival, resolution process. If it is not happening within the parameters of law, go for liquidation. Nobody is saying after 330 days, sorry, goodbye, we will go for the liquidation. No difficulty. At least in the eyes of entire world, the India as a country would say that yes, there is a liquidation process, it failed. There is a resolution where it failed, so therefore you have gone for the liquidation. That's a time-bound program. If you come and invest in our country as an outsider, so this is the process you must follow.
Shubham, Mr. Patnaik is making an interesting point. The idea is the reason you have taken the company into the resolution process is because you want to revive the company, and to revive the company, you need electricity, you need information technology services, and to ensure that you're able to come out of the resolution process. If those things are denied to you, you will not be able to come out. And the safeguard that is being provided is that the services that you are providing during that moratorium period, essential services, you will have a priority for payment of dues. Is there anything else that needs to be done to ensure that the company, has a better chance of revival?
Well, yes, that's true. If you look at it, like again, it's a question of which company will need what sort of provisions to stay alive. Can't really be a sort of a blanket sort of thing. Sectors will decide. So what could be essential for one sector might not be adequate for another sector. So that of course will have to be looked at case by case. I really don't think there's anybody who can, writing a law, can sort of put that into regulations. What is it? Essential itself is a very subject, is a something that will need to be written in. Need to be looked at case by case, that what constitutes essential. So there are those factors. But what it also, again, similarly supplies, government supplies, government permits and other things which have been given, which tends to be often less than, it could just be a year. And the company may not have time while it's gone into liquidation process, under the resolution process, to apply again, because they wouldn't be the because the company secretary itself, they themselves are handicapped for applying for those licenses again. So those problems will all be there. GST, for instance, has to be applied for every year. So those sort of things do create a problem. So those things need to be sorted out through, and it will, again, as I said, it will have to be on a very case to case basis, depending on what the RP professional, the resolution professional, decides as are the essential things to keep the company going.
Okay, Mr. Patnaik, one of the interesting things that you and I were talking about at the beginning of the program is the changes that have gotten into the law. Now, clearly, after the laws come into place, all of us are learning as to what are the different requirements in that insolvency process. How do you see this space moving forward?
As I stated, that it's a step in the right direction. But I'll tell you what, it's a beginning. It's in the nascent stage. Today, to say that yes, because the amendment comes only when it's a necessity, that the requirement of the society or the nation at large, that what is that industry is facing, what is the common man is facing. That is why these amendments, home buyers amendment, or for example, for the essential goods, you would not stop supplying. The permit and the licenses. Suppose, for example, I have a permit, you would stop giving me permit because you are under the resolution process, those things stop. But one of the most important aspect which has been taken care of here is the directors, the ex-directors or the promoters. The general tendency that yes, you have a casting aspersion on those directors, but those people are not debarred in prosecuting, or if you have any grievance, you can proceed against them, criminal or civil for that matter, you can proceed, and they are not barred, particularly when the IRP is appointed and there is a chance that yes, the new management come into picture, they are not liable, the earlier management liable for entire action as well as for the related party. Whoever are liable, it is those people, not the present management.
Okay. Shubhamay, close the program with us with extremely brief comments about what you think about the legislation.
Well, I think it's a good one, and as I say, this will not be the last one, because there would be subsequent amendments that would be necessary. The very fact that they are willing and able to go for quick changes at whenever it's necessary is, I think, one of the best things of IBC.
Great. Thank you, Shubhamay. Thank you, Mr. Patnaik, for joining us into the discussion. It is time for us to end the show. You can watch our shows on the RSTV page of YouTube. We will be back with a new issue and a new episode. Keep watching Rajya Sabha TV.